So first, I just want to say good evening to everyone. I'm so glad that you could all join us tonight. There's really a diverse audience, and I'm really thrilled to see all of you here. Hi, Carol. For those of you who do not know me, my name is Kimberly Connell. I'm the Caregivers Support and Services Specialist with Onondaga County Office for Aging. And when I ask my caregivers that I support what topics that they would most like the eye care classes to focus on, Medicaid is always in the top 5. Because as I said, there's so many aspects of Medicaid that are a confusing mystery to so many. And so tonight, on behalf of Onondaga County Office for Aging and Caregiver Services, I'm really very pleased to welcome you all to our Institute for Caregiver class, Making Sense of Medicaid with Moen Thurston, attorney at law. We're really fortunate to have Morgan presenting this evening. Morgan is an assistant welfare attorney with the Onondaga County Department of Social Services, where he serves as the attorney for chronic care and protective services for adults units. Morgan is also a partner with Moen Thurston, which is a general practice firm with a primary emphasis on estate planning, real estate, and income taxation. And Morgan is also a member of the Estate Planning Council of Central New York, the New York State Bar Elder Law Section, and the co-chair of the Syracuse Area Domestic Violence Coalition Elders Abuse Committee. So I don't know how you,
Morgan is also a partner with Moen
I don't know how you do it all.
which is a general practice.
Hang on. There we go. So I'm going to turn you over now to him. We're in good hands. Hold on a second, Morgan. I'm going to spotlight you for everyone and remove me. There you go.
All
Okay,
right.
take it away.
All right. Good evening. Good evening, everyone. It's a little weird talking to a screen. I've got my PowerPoint up and hopefully everyone's seeing that. I think you all are. I've done this presentation before, and again, doing a Zoom's a little different. So if there are questions as we're going along, so you don't forget, because it's hard for me to see them, type them in the chat or raise your hand, and then we'll follow up on them. But Medicaid in 2022, making sense of Medicaid. The title's a lie. I can't make sense of Medicaid in an hour period. I've been doing this for going on 20 years and I'm still making sense of it. There's always something new, but so it's a complicated topic, and there are changes this year too. So we'll get through as much as we can, and hopefully I can shed some light on the topic for everyone. So getting started. There we go. First of all, just briefly, we'll talk about Medicaid versus Medicare. So Medicare is a federal health insurance program. And if you're age 65 or older, if you're under 65 with certain disabilities, or if you're at any age with end-stage renal disease. So Medicare, health insurance, and for Medicare, there are 4 different parts. Part A is your hospital insurance. Part B is your medical insurance. Part C is Medicare Advantage plans. And so they're private insurance options that can cover hospital medical costs. And then Part D is your prescription coverage. The Department of Adult Long-Term Care Services has some assistance on helping people figure out which plans work best for them. But we're not the overseer of the program. The part that I am involved in and what we're going to talk about tonight really is the Medicaid system. So Medicare, think of that. The major distinction is Medicare is health insurance. Medicaid it's a program to assist low-income persons in attaining and paying for medical care. So where Medicare is insurance, Medicaid is a benefit. It's a public assistance benefit. So because it's a public assistance benefit, and as the slide says, to assist low-income persons in attaining and paying for medical care, the system to actually locally, the local departments of social services, so I work for Onondaga County, we administer the program in part, but we actually are doing it as really an agent of the New York State Department of Health. So we will make determinations and we handle applications. Ultimately, we'll talk about fair hearings a little bit today, and we will represent our determination on fair hearing. And for chronic care Medicaid, I'd be the attorney that would be appearing on those. But ultimately, the Department of Health is the overseer of the program for New York State. And it's also a federal program from the Centers for Medicare and Medicaid Services. But always, Medicaid is the payer of last resort. So if you have another payment source, being health insurance or Medicare as your other secondary health insurer or your primary health insurer, or if you have assets or resources that make you ineligible for Medicaid, Medicaid's not going to provide services to you unless you qualify. A common thing I hear when I speak with people is what they will say is like, well, I don't want the state to take my house. I don't want the state to take my resources. Well, the state won't do that. What happens is that you have to private pay for your care until you're eligible for the system. So it's not you paying your assets over to the state. You're actually going to be paying your funds over to the nursing home until there's a time period that you're eligible. You still may have a contribute, and you could be contributing your income as well. So it's not you don't lose your assets to the state, you lose your assets to the nursing home that's providing care to you. Right now, big change, and we're still dealing with it. But we've been dealing with it since March of 2020. We are still under a public health emergency. So COVID is still impacting how we handle Medicaid applications, how we process Medicaid applications, and until we're out of this public health insurance emergency. Most recent thing we learned was that the public health emergency is going to stay in place at least through January 11th of 2023. Indications, I think that will probably be lifted at that stage, but we're in the emergency until then. Health and Human Services, that's the federal government has stated that it'll give states a 60-day notice prior to the end of the public health emergency. So we're continued through January 11th, so it might be extended a little bit beyond that, but it's kind of what we're thinking is that time frame. So there's different rules that apply during the public health insurance or emergency. One of them being for chronic care Medicaid applications. We are still asking for you to complete a Medicaid application and submit documents. But if you can't do the public health emergency, you can attest to income and resources rather than providing the documentation. And that will continue until, again, we reach the end of the public health emergency. So I mentioned there's big changes. So April 8th of 2022, for this year's, the New York State budget included an expansion of Medicaid for New Yorkers 65 and over, and also those who have disabilities, and also for undocumented immigrants 65 and over. So we're going to go through what those changes mean. They don't come into effect until January of 2023. So the first part of my presentation, I'm going to go through the figures that are in existence for this year. But I have a slide that's going to show you what next year will probably look like. It's an estimate right now, but this is what we're probably going to be looking at. Another change we talked about when I did this presentation last, New York State has also looking to implement a look back period for home care and for community-based long-term care. So that's a change. This was enacted back in the budget of 2020. And the look back was intended to start on January 21st of 2021. But due to the COVID and the public health emergency, that has been required to be pushed back. And at the earliest date that we're going to be looking at look back periods for community-based for home care is going to be March 31st of 2024. That's the earliest we're going to see. So look back is what we can ask you to, that information. We're going to go over a little bit more about information and how far back we can look at your documentation and see where your assets were and income were back during that time period. What New York State, they may require a look back for home care and other, we can require this. The state has actually requested a waiver for a 30-month look back rather than the 60-month guideline that the federal government requires if we're going to implement it. So, but we're asking for this waiver, so it'd be a shorter time period than what we do for chronic care Medicaid. We'll see. We don't know yet because we're not going to be implementing it for another year and a half at least. States, we may not require a look back for community Medicaid for hospital care, acute or primary care. So it's a change for New York, we think, but it's not as, it's not going to happen as quick as we anticipated it happening. So just a little more clarification on that. Which community-based long-term care will require a look back? Personal care services, consumer-directed program, private duty nursing, assisted living programs, if they are Medicaid sponsored. Not all assisted living programs have Medicaid beds. Adult health care, adult day health care, Medicaid Advantage Plus and PACE enrollment, certified home health agencies, and some limited licensed home care. So not all home care, but these are some of the programs that will be requiring look back when and if we ever get to it. Again, no look back is required for certain other programs, some of them being nursing home transition program. This is a Medicaid-based program too, designed to keep people out of a nursing home or have people leave a nursing home and go back in the community for care. So it's a different managed program. People with traumatic brain injuries, that's a different Medicaid waiver program. Office with people with developmental disabilities, that's a different waiver program. So there's a lot of other programs, but again, mainstream managed care does not have a look back, and acute primary care in the community or hospital will not have a look back period on it. So what we've been talking about, there's really 3 levels of Medicaid coverage. Basic Medicaid, which is, will provide health, and it's not health insurance. Again, it's a public assistance program. Medicaid home care that we're just talking about a little bit. And then Medicaid chronic care is the part that I deal with the most. That's who I represent. That's the chronic care is the nursing home coverage. And that's when I was talking about spending your assets down and giving everything to the state. Well, it's actually the nursing home, and it's not everything. You do get to keep some items, but chronic care Medicaid is nursing home coverage. And that's pretty much what we're going to spend the most of the rest of the time talking about is nursing home, chronic care, Medicaid. Coverage for nursing home care is the highest level of coverage. It's the most expensive level. Well, it can be the most expensive level of coverage. Some of the home care waiver programs might be more, but it requires documentation of resources for the 5-year period prior to application. That's your look back period. This is a time frame you've got to, so if you apply, you're going to be looking back or providing documentation for 5 years. Again, during the public health emergency, if you can't access documents due to the public health emergency, you can attest to what your assets are. Assets and income are. So that's still operating under that change. Application date is the date that our office actually receives the application from the individual requesting coverage. This date is important because your coverage can begin as early as the first of the month, 3 months prior to the application date. This is the 3-month retro period. It's called the retro period. So if you apply today, well, here's the example. So if you apply on today, the coverage could begin as early as July 1st, 2022. So getting it in by the end of this month would take it back to the beginning of the 3 months back, the first of that month. So really what this means to you, that 3-month retro period gives you a little bit of leeway, so you don't have to apply before someone went into a nursing home. You don't have to apply the first day, the first week. You really would get 3 months. So sometimes you really need that to figure out whether the person's going to be eligible too. So that's application date and retro period. So the applications, they get assigned to staff. And what you're likely going to do is you're going to get something called a pending letter from the person that's assigned to your case. The pending letter is just going to be asking you to provide further documentation. And it'll have a time frame on it too. It'll tell you when the documentation is due. The key there is that you stay in contact with the person that is assigned to your case. So if you're having problems gathering any documentation, make sure you're in contact with the caseworker income maintenance specialist that's assigned to your case. If you can't reach them, there's always a supervisor of the day that you'll be able to reach with a question, but you want to make sure you reach out or in contact with the agency. We used to have to require face-to-face interviews. And again, we not required to do that anymore unless it's requested by the applicant and the representative. You could do it. We can do them remotely as well, but that's something that used to be on every application. We required interviews, and that's gone now. I don't know if it's necessarily, probably for our workers, it's a little bit initially, less work because you don't have to sit down with every file, but I think sometimes face-to-face interviews can resolve some issues because you get on the same page with the case worker and might be able to figure out some things that are missing and understand the process a little bit more too. But again, they're no longer required. Again, it touched on this, that it was a program for low income. It's based on financial eligibility. And but for nursing home coverage, it's both income and resources, and that's your assets. And it's not just for the person that's applying; it's also for any legally responsible relatives. So for a chronic care nursing home, legally responsible relative is almost always going to be a spouse. So if you're married, that we're going to ask for the documentation, not only from the person applying, but from the spouse as well. And then you'll see sometimes terminology and working for the government, we're prone to do this. You'll see acronyms, you see shortened abbreviations. One of them you see sometimes is something called an IS. That's the institutionalized spouse. And that's the person who's actually in the medical institution and is expected to remain in that facility for at least 30 consecutive days, or is in receipt of home and community-based waivers and expected to receive such services for at least 30 days, or is active in the PACE program, and that's the program for all-inclusive care for the elderly, or some combination of A and B, and they are married to the person who's not described in items A through D. So we have the institutionalized spouse. So that's the sick spouse, the person that needs care. And then we have a community spouse. That's our spouse, the institutionalized person, and they're not expected to receive home and community-based waiver services. So they're residing out in the community, not expected to receive services either. So one of my favorite abbreviations is the MMMNA, the minimum monthly maintenance needs allowance. It's certainly a mouthful for me to say. This is the income level that the community spouse is allowed to keep or to retain. In 2022, the MMMNA is $3,435. So if the well spouse, the community spouse, they have $3,435 of income, they're entitled to keep all of that. If perchance the community spouse has $4,000 per month in income, we are going to ask that community spouse to contribute to the institutionalized spouse cost of care 1/4 of the amount over that $3,435. So say it's actually the person has $4,035. I actually have a slide. Next one, I'll show it to you. If the community spouse is below the minimum monthly maintenance needs allowance, the institutionalized spouse can contribute their income to bring the CS up to that level. So if our community spouse only has $2,000 a month in income, but the institutionalized spouse has the same $2,000, well, they can take $1,435 will be allowed to be contributed to the community spouse to bring them up to that level. That's the level we want. The government says that the community spouse should be allowed to be maintained at. Net available monthly income. This is the amount that the applicant is required to contribute to their cost of care. So this is our institutionalized spouse or just our applicant recipient. So they have to contribute income that they receive on a monthly basis over to the nursing facility. So for someone that's single and permanently placed in a nursing home, it's going to be their gross income minus allowable health insurance premiums, minus a whopping $50 personal needs allowance. This figure has not changed since I've been with the county. So we're 20 years in, it's much longer than that. They've never changed this amount. So the person that's single and permanently placed, all they get to keep is $50. All the rest of their income is either going to go towards their cost of care or potentially to their community spouse. And allowable health insurance premiums, it could be a Medicare, your contribution towards your Medicare, or if you have viable or cost-effective third-party health insurance, we may ask you to continue paying those premiums. Because again, Medicaid's the payer of last resort, so we're going to allow you to make those contributions to keep that health insurance. But that's a determination that we'll make, and we'll tell you whether it's cost-effective or not. So if you're the net available monthly income, the NAMI, for someone that is single but only temporarily placed, you're going to get to keep the community level of Medicaid for that, minus the health insurance premium. So for 2022, that level is $934. So if you had to go into a nursing facility for a short period of time but it's not permanent, you'd continue to keep your $934, not the $50 a month. So if you're married, first community spouse's income is compared to that minimum monthly maintenance needs allowance, the $34.35. And if this community spouse's income is below that level, then the institutionalized spouse can contribute to bring the community spouses up to that level. So again, I use the example, if they're at $2,000, they could contribute up to $1,435 to that spouse. The remaining income of the institutionalized spouse, health insurance and $50 already deducted, is the NAMI. So contribute to your spouse and keep your $50, pay for health insurance. Everything else would be paid to the nursing home. So again, if you're married and the community spouse is above the minimum monthly maintenance needs allowance, 1/4 of that amount is added to the institutionalized spouse's contribution for the total NAMI. So if you're over that amount, we're going to ask that community spouse to give 25% to the institutionalized spouse. So if you're over by, $3,435, if you had $4,435, you're over by 1,000. We ask that community spouse to contribute 25%. So that'd be $250 directly towards the net available monthly income of that institutionalized spouse. So spend down, that's a common Medicaid term, the use of medical expenses to both reduce the net available monthly income and reduce resources in excess of the medically needed income and resource levels. The spend down's not available to everyone. It is available, not everyone seeking Medicaid, but those that are SSI related, which means you're either disabled or you're over 65 years old. So you can spend on your assets and income to be eligible for cost of care or for care. So we look at resources too. And what are your resources? Really, it's your property of all kinds, including real and personal property. Bank accounts, it's pretty much everything. Certain types of resources, there's some exempt resources, and certain types of resources are handled differently. And one of the largest resources that people have are like IRAs and 401ks. They get handled slightly differently. If your IRAs or 401ks are being paid to you because it's part of a required minimum distribution that the IRS makes you take, and you're in payout status, it's going to be treated more as an income stream rather than a resource. So it'll get counted one way or another, but so depending, those are really the major differences. If for your tax deferred assets, they get handled differently. So you do get to, for the person that's in the nursing home, they do get to have a resource level. For 2022, it's $16,800. If you're over $16,800, you have more than that in your bank account. Those resources can be spent down on viable medical bills. And that would be something that you would submit medical bills when you submit the application. We would be able to tell you whether you could spend down those excess resources. But again, for this year, it's $16,800. Next year, it's going to jump up quite a bit. And that's a big change based on this year's budget for New York State. So community spouses, we have to, that well spouse, we have to, when you're married, you're deemed you're an economic unit. So we not only need the income and resources for the institutionalized spouse, but we need them for the community spouse too. And the community spouse gets to keep a different amount than the institutionalized spouse. Community spouse gets to keep $74,000 between $74,820 and the maximum is $137,400. And this is just yet another complicated. It's a minimum of 74. The max is 137. It really depends on how many resources the person has when they go into the nursing home. Not the application, it's when they enter the nursing home. And then we will tell you what the maximum amount of resources is going to be, but that's where it's going to fall. So the snapshot is actually the date that the applicant is seeking coverage for Medicaid. And we're going to look at the total amount of resources owned by the applicant and the spouse on this day. And it's calculated compared to the allowable resource level then. The look back period is the period immediately preceding the date that the person is seeking Medicaid. And the look back period for chronic care Medicaid is 60 months. And that's for all resources, including trusts and annuities. So we're going to ask you to supply us with 5 years look back from that snapshot date. So individuals looking, the look back starts 5 years from the date seeking coverage. We give that 3-month retro period. So, but no, you're going to be looking back 5 years. And eventually when the community-based long-term care gets phased in no earlier than March of 2024, would be phasing into 2.5 years there, but 5 years for nursing home. Resource explanation sheet. So part of what what happens with this look back period, you're going to give us the 5 years worth of all your records, your finances. We're going to require that you give us a written explanation of every deposit withdrawal into any accounts which have been opened within the look back that are over $2,000 or more. We can look at other asset or deposits or withdrawals less than 2,000, but if we see any, you should be mindful if there's any over 2,000, we're going to ask you to explain where the deposit's from or where the payment went to. So maintaining those 5 years records and keeping good financial records is important. And this can be difficult when you're coming in and trying to assist someone to apply for Medicaid when you haven't been assisting them for 5 years or assisting them at all, to try and recreate the wheel for 5 years. It can be hard, but this is one of our requirements that we're going to ask you to do. And documentation of the source of deposits and the reason for withdrawals will be required. So we want to know why and where this money is going, and we'll get into why that we want to know that. And as far as documentation goes, it can include deposit withdrawal slips, copies of your canceled checks and receipts. We don't need documentations for each deposit for regularly recurring deposits like your Social Security or pension. We're just going to want you to show something that establishes what that amount is, like if you get a COLA increase on your Social Security or an update on your pension statement. Give us one of those so we can verify where it's at and show us that documentation. Transfers, this is where issues become for penalties within that look back period and becoming eligible for Medicaid. Transfers are a voluntary assignment of property for less than fair market value of the property. And really, the point of the look back period is that we're examining your finances to see if you made any transfers that may make you ineligible for Medicaid. So the uncompensated value is the difference between the fair market value at the time of the transfer, less than the outstanding loans, mortgages, encumbrances on the asset, and the amount received for the asset. So if you had a house that was worth $100,000 and you had a mortgage on it for $50,000, really the value we're looking at is $50,000. If you just assigned that house over to a child or someone, it was for no value at whatsoever, it would be the $50,000 we'd be looking at. We'd take that mortgage off of there and we look at what you actually received. And was it fair market value at that state at that time? So penalty periods, that's the period of ineligibility for certain services because of a prohibited transfer. Doesn't mean you can't make it. The transfers aren't illegal. You transfer, do you give a gift to a child or someone? It doesn't make it illegal. And I've had a lot of people say that. I didn't, it's not a fraudulent transfer. It's just that transfers for less than fair market value might make you ineligible. So the penalties apply when the individual is otherwise eligible and seeking nursing home coverage. So the penalty period, this has changed from 2006 to now. So it's been a long time, but it used to be the penalty period would start the month after you gave something away. Now it doesn't start, the penalty period doesn't start until you're otherwise eligible. So you meet the income and resource levels and you're otherwise seeking nursing home care. And the way we determine the penalty is we divide the uncompensated transfer by something that's called the monthly regional rate. And that's established each year. We don't set it, New York State sets it. I'm going to show you a little more on that. So that regional rate changes yearly and it varies within the state. There are 7 regions within New York State, and we're in the central region, which includes Onondaga County. And for 2022, the regional rate is $11,328. So the regional rate is based on the region the nursing home is located, the applicant resides in. So if you're in Onondaga County and the resident, and you apply for Medicaid while residing in a nursing home in Suffolk County, the regional rate for Long Island would be used for that penalty. So if you are an Onondaga County resident, but in a nursing home in a different county, we look at that region's rate. And I will tell you, the Long Island region, their rate's going to be much more than what our Central New York one is. We're I think we're the second lowest in New York State. Well, it only goes up from there. Obviously, New York City and then Long Island are the two highest regional rates. So the way the penalty period works, if the applicant is determined they transferred $50,000, that was kind of what I was using on that house for less than fair market value. So you gave away $50,000 for less than fair market value. We divide it by $11,328. That creates a penalty period. It makes you ineligible for Medicaid for 4.41 months. So the person will be ineligible for 4 months of nursing home coverage, with the remainder penalty of $4,688 for the 5th month. So you'd have to contribute that much in that 5th month, but the balance of your payment for that month would be covered by the program. So this is an estimated figure space for 2023. I told you there's a big change coming for next year. The rates are going up quite a bit. And I got these figures from the Western New York Law Center. They have a lot of useful information on Medicaid program. It's not the New York State Department of Health System. They're not going to guess what this is, but these are estimates that they came up with. So the income limit for next year for this SSI related people that we're talking about nursing home will increase to 138% of the poverty limit for next year. So using this year's February poverty limit, sorry about that, the 2023 limits would be for a single person. It's going to jump up from $934 to $1,563. So not quite double, but it's a really large increase. And for couples, it goes from $1,367 to $2,106. So another large increase. And then the asset limit. So for a single person, we were just talking about $16,800, and it's going to go up to $28,134. The couple increase, this is different. That's not the couples we're talking about for institutionalized spouse and community spouse. This is more for couples increasing from for community Medicaid. So, but that's a large increase as well. What this has done, these increases in income and these increases in the assets have changed some of the Medicare savings programs in New York State too, where part of the Medicaid would maybe contribute towards your Medicare premiums. Now, the QIMBY program, all people who have Medicaid under the new expanded limits without a spend down will be eligible for QIMBY. And another one that we used to talk about was SLIMBY. That program will no longer exist in New York State because anyone who had SLIMBY will now get QIMBY. So because the way the increase in the limits. And I apologize that as I'm doing this presentation, I see all the different acronyms, and I know it's we're trying to take some of the demystify Medicaid, but it's almost next to impossible to do. There's just a lot of different terms and factors. But
Morgan,
so,
this is Kimberly. I just
yeah.
have, what is QIMBY? Because I don't know what that is either. QMB.
Yeah, so it's a Medicaid.
Go ahead.
It's a Medicare savings program where
Okay.
if you meet the payment program, so if you, depending on where your income is, we'll allow you. You'll get a Medicaid grant to pay for your Medicare premium.
Right. Okay. I've never heard it called QIMBY. I know the Medicare savings program, and someone did ask a question.
Yeah, that is one of the qualified. Yes, so that's what they are.
Oh, what is it? Qualified?
It's yeah. Now I'm going to draw a blank.
Okay, it doesn't matter. It's a Medicare.
Yeah, it just falls under. It's Medicare savings program.
Okay.
All right.
Yeah.
Sorry about that. So that's a big slide to have, the projected, but again, they're estimated because we don't know 100% what the 2023 federal poverty limit is going to be. Well, what can you do now? Well, talk to family members. So if it's someone, if it's you, or if it's a family member that you think you might be having to assist, start having the conversations, and begin gathering the information, getting it in one place. At least having a list of where they might be able to find stuff. You can make their lives a lot much easier, or you can, they can make your lives that much easier. Consider appointing a power of attorney. So at my introduction, I played my two major clients at the county are chronic care Medicaid and then adult protective services. My role with adult protective services is one of them is going after people that have abused powers of attorney. So powers of attorney are powerful, they're important documents. It's where you're giving someone, while you're alive, authority to manage your finances for you. But you don't want to enter into them lightly. You want to be aware who you're giving a power of attorney to. And a lot of people want you to be mindful too that if you do sign a power of attorney, you're still the boss. You have the full authority to revoke or amend a power of attorney. And the changes in the statute make it really clear that the person has to sign the document with you, and they have to sign something saying that they understand that they have to follow your wishes. And if they don't know your wishes, act in your best interest. And they have to keep an accounting of everything they do on your behalf. But I don't have a better way to have someone assist you if something happens to you, if you become incapacitated. Short of signing a power of attorney, if you had a stroke or some other incapacitating illness, without a power of attorney, they may have to file a guardianship on your behalf if they're not on all your accounts where they could access something. And you're not going to have a co-owner on an IRA or 401k. So power of attorney can be very, very powerful, but very important. I don't have a better way to handle finances, allowing someone to assist you than that. The Medicaid process can be long, it can be involved, it can be frustrating. I fully appreciate that. Your patience is always appreciated. Nursing homes too, they're aware of how long this takes. All right, they know if you've applied, they can assist you. Some nursing homes will want to assist you. And they understand you're going to continue to receive bills from the nursing home during the application process. And these numbers can get large and scary. But again, while the application, you don't need to spend on your resources below what your limits are until your determination is made, whether you're found eligible, and the nursing home should be mindful of that. So not that you shouldn't be communicating with the facility where your loved one's at, but they need to be patient as well and wait as long as you're doing what you need to do to get the process going. I mentioned this earlier. Always keep your assigned Medicaid worker aware of any changes and where you stand with the information gathering process. And if you run into a roadblock trying to gather information, or if you have a question about something, reach out to them, let them know. If you have an application, a pending letter where stuff is due by a particular date, and you're not going to have it done by that time, make sure you request an extension and tell them why, what you've done and why you need the extension. And it's part of our job is to work with you, but the applicant recipient, they bear the burden of providing the information to the agency. So you need to stay on top of it and stay in communication with our office. In the past, extensions were given without the need to document the reason. And that actually added to the contribute to the time that it would take us to process applications. So in an attempt to help streamline all applications, where we do limit extensions. And if you fail to provide the information or ask for an extension, your case can be denied. I represent the agency at fair hearings when people have their applications denied for any number of reasons. I would say over the last 5 years, the number one reason why most applications get denied is for a failure to provide information or a failure to ask for an extension. So that's staying on top of your case is the most important. We go through the stuff that is submitted, painstakingly reviewed. Sometimes it feels like it is painstaking, and I understand, and that it can be frustrating for people that they want answers. They want to know whether they're eligible. They want to know what we're looking at. But we do look through these 5 years records. It's part of our obligation. By law, to maintain the program, we have to do that. Making sure information is legible and complete as possible. It's kind of self-explanatory. The better the information that's coming into us, the quicker we're going to be able to process it and move it through. And be mindful, and this is a frustration, I know people have it, is like we send someone a pending letter and we ask for X, Y, and Z. Well, you submitted information pursuant to our request on X, Y, and Z, but the information you provided may lead us to ask questions about A, B, and C as well. That's just part of the process. If we see we see a deposit coming in from another account that you own that maybe you forgot to give us information, that may cause us to ask more information about that too. $2,000, I already mentioned this too. We're going to ask for documentation on transfers or withdrawals or deposits over $2,000. But if we see recurring deposits or withdrawals at $1,999 every month, we will ask about that as well. So that's something to keep in mind. Other things to keep in mind: if you routinely mix money in one account between family or friends, seriously consider stop doing that. Okay? I have a lot of clients in my private practice when I do estate planning and I do wills for people. We talk about jointly held assets where they say, I have my son or daughter on this account with me. They're a joint holder on this account. The one thing they don't, well, sometimes they do understand is I need to make it clear is that when you pass away and you have a joint account with a son or a daughter, that son or daughter owns that account when you pass away. And a lot of clients will say, well, they're going to do the right thing with that asset. And I say, okay, that may be the right thing to them, may be keeping all of it. The right thing for many of them, they're going to split it with their siblings. And I have had a lot of clients that they do that. But sometimes they might not be able to. If you had a joint asset with a child that was, maybe they had a stroke or a medical emergency, or then maybe they wouldn't be able to split it with their siblings at that stage. So that's where a power of attorney could be important. I'm not telling you can't have joint accounts. It's just that I want you to be mindful of what the legal result of having that joint account is. The other thing is if you had that joint account with a son or a daughter and they're depositing their money into your account, the presumption on a joint account when there's a Medicaid application is that all the money belongs to the applicant recipient. So if you're commingling funds and they're depositing their money into your account, then they're going to want credit back out for that. You need to be very careful on that. You need to be able to document it because it could result in a penalty, even though it really shouldn't have if you can't document it. Because again, the presumption is that it's all your money. If your relative does not handle money, has another in who will pay their bills and then reimburses them monthly occasionally, then randomly stop that process. Have a way to have a clear paper trail of the expenses a person incurs for themselves. And if everything's in cash, and they take out large amounts of money every month, and that's the way they handle their finances, that can create problems. So those reimbursements, and it could be perfectly valid. It's just that our presumption, we don't have a way to establish that. Again, monies transferred for less than fair market value in the look back period are presumed to have been done to qualify for Medicaid. So the burden switches back to the person applying to show that it wasn't done to qualify for Medicaid. And this is why. So that's just our advice, is that try and keep a clear paper trail where how money's being handled, where expenses are being paid. Saving receipts for big ticket items. And 2,000 is a good starting point, but any other large ones, keep track of where, keep the receipts. Start making clear legible notes on bank books and check registers. Communicating with family members, letting them know where they can find stuff, or maybe in the list of where your assets are, so at least they can help. It's going to make it easier. Other things to keep in mind, Medicaid rules are not IRS rules. We use different charts than the IRS does for mandatory deductions. I talked briefly about IRAs and 401ks. If you're over 59 and a half, or you can take money from an IRA or 401k. After 70 and a half, you have to take money. You require minimum distributions. IRS has a figure. When you come in to apply for Medicaid, we're not going to make you liquidate your whole IRA or 401k, but we're going to make you continue to take distributions from that. We may ask you to take it at a faster rate than what the IRS said. It's going to be based on your life expectancy. So that's a factor too. You have a right to a conference to discuss a decision you don't understand or do not understand or disagree with. A little typo there for me, sorry about that. Additionally, if you ask for a conference, you still don't like our answer, you have the right to a fair hearing on any action you don't agree with. Please read all correspondence carefully, because there are time limits on requesting fair hearings. So you're going to get a notice. And if you don't like the notice, you can always talk to caseworker, you can always conference it, but read it and see what your timeline for filing a fair hearing would be. It'll give you the instructions on how to do that on the notice that you receive as well. And I think that is the last slide.
Okay. Thanks so much.
I know that's a
Morgan,
lot.
I'm telling you, my head's spinning, and I'm more familiar with some of this than most of the people who are attending this evening. So I'm sure it's like, what?
That's why I said it's a lie when we say we're going to make it demystify. It's so much information and so quickly, but
yeah.
I mean, and obviously I don't know how it's been live streamed that you can watch it again, but the slides can be made available as well.
Yes, I will. I will definitely make the slides available to folks, because I think my favorite part of them all is things to keep in mind. There's like 10 slides or so that really sort of encapsulate a review of a lot of what you said. So I think that's really helpful, and I will definitely provide that for folks. But we did have a few questions I want to go over, and I actually had a few things I wanted to clarify too. You know what? First of all, I want to ask one of the questions that was sent in with the registration. Now, someone did ask about the how to get the Medicaid to pay for Medicare premiums, which isn't exactly the right terminology, but that's what we were talking about with the
Medicare savings programs. Yep.
Yeah, and what I'm going to send out with the follow-up email. Now, I'll be sending a follow-up email out with the PowerPoint presentation, a few other resources that we discussed during the class, and also a link to the recording, so you'll have that. So I think that will answer your questions, and it's really income-based. So, and another person who registered asked about documentation that's needed to apply, and I think that this was for documenting their identity, because he asked if the birth certificate is original from 1929 and so worn and so and ripped, do I have to get another one? Or can I use a driver's license that's expired? It was expired in 2020. Will that be accepted in terms of proving identity? And I'm not sure what you need for identity.
Well, and we do run into problems where people have no identity, and that is a problem. But, you know, a ripped or torn or old birth certificate will be fine. I see a lot of scanned copies of those. An expired driver's license, that should not, I don't think we should give you a problem on that. And
Okay.
I'm guessing a little bit on that, but I don't think that will become an issue, because it would have been able to be validated with some of your other information too.
Okay.
In that QMB is the program it's qualified Medicare beneficiary. So it's just one of the Medicare spend down programs.
Okay. And that's funny. I've never heard of that, but I certainly know the Medicare savings program, because I do discuss that with folks that I talk to on a regular basis. And I have a flyer that explains that program and some other cost savings programs as well that you may want to utilize that aren't directly related to Medicaid. So way back when, there was a question about what is chronic care Medicaid, and I did want to clarify that too. So you have community care Medicaid and chronic care Medicaid. Now, chronic care is when you're applying for Medicaid for a skilled nursing facility.
That's correct.
And then community Medicaid is really the home. Well, it's not just home care, but it's
Right. Yeah, there's the gambit of, there is just straight Medicaid, which
is just like insurance, right?
It is a insurance that you have to qualify for financially. All right. It's
Right.
But that's just straight. It's going to be coverage for your medical.
Yeah, for your
It's not
medications,
insurance, but it's
doctor
coverage.
visits, hospitalizations, things like that.
But in between chronic care and straight Medicaid, then we have those home care programs. And again, we had those 2 slides on there that list all these different programs. Some will have a look back, some won't. So assisted living is technically, it's a congregate care type of care, but it falls under the different rules than chronic care.
Oh, okay.
It's
Okay, and then,
community-based.
so assisted living may be a different category.
Well,
Although there are some.
it's not chronic care. All right. So technically it's a community-based program, but it's going to likely have a look back period in 2024. So
In
it's not
2024.
your straight, yeah.
But today, or in the next 6 months, let's say, an individual has a loved one that they think would benefit from assisted living. And there are some assisted living programs in the county, primarily through Loretto, who accept Medicaid.
Right.
Then they would apply for not chronic care, but community-based Medicaid to have that paid for.
Right.
Okay. Got it. Okay, that's interesting. And that's a different level. So, but, and right now, all of this really complicated documentation and lookbacks that are not needed for that kind of Medicaid right now.
Right.
But
It's
if
just-
someone is planning for the future, which is 2 short years from now, then you want to make sure that you start documenting, just like you mentioned for chronic care. So you want to make sure that you and your loved one or whoever you're caring for, you have the documentation of the bills that they're paying and anyone that they gift to and so forth, so that they, right.
And again, we asked for a waiver. New York State's asked for a waiver to say not 5 years, but 2.5 years, but that has not been approved.
Oh,
So these are the community-based long-term care services, not chronic care, but community-based long-term, that will have a look back. Again, personal care services, probably the assisted living programs, adult day healthcare.
wow. It would be, I hope that they do accept that 2.5 year look back, because to look back
Yes.
5 years for adult daycare would be very difficult. And
Right.
and it would be a barrier to folks in the community getting those services. Okay. And speaking of that, I had a question about that because I believe that you said that some of the home care, the licensed home care agencies would not have a look back. Was that something that you said?
So these are the ones that won't have a look back. So nursing home, NHTD program,
Oh, okay.
TBI program, OPWD waivered, and then some Main Street managed care.
Okay. But any kind of home care, a licensed home care agency who's going to come into the home and provide care, that would be there, that would qualify for the look back period when
Right,
it's
so-
implemented.
Limited licensed home care services agencies operated by adult homes, and then personal care services and child services, yeah. So all
Okay.
those would fall under that look back.
Okay. Okay. Got it. I don't know if anyone, if everyone got it, but I think I understand that. I hope that clarified it. Then one other question that someone said, and I do recall you talking about this back when, can the legally responsible person on the application, and you indicated that that's generally the spouse, can it be the child of the applicant if they're caring for them and living with them?
No.
Okay, so that's always,
So yeah, it's legal. A child's not going to be legally responsible. There are some states that have said a child is legally responsible. New York State does not say that. One thing that people run into issues with is, as a power of attorney, as a child, when you go and apply for a nursing home, they can't make you sign a guarantee that you're going to pay for your loved one's cost of care. That's illegal. They can't do that. What they can do is, if you're the agent under a power of attorney, they can ask you to sign something and say, you'll, to the best of your ability, you are going to use that person's own funds to pay for their cost of care. There's a
okay,
big distinction there.
yes.
You're not taking on the liability for yourself, but you are saying, yes, I'm going to do the best of my ability, use their funds to pay for their care.
Okay, excellent.
We still have a rate of spousal refusal in New York State. Some states have gotten rid of that. A spouse can say, I'm not going to use my income or resources to care for my spouse in the nursing home. That may very well result in a letter from me saying that we're going to pursue that, because that spouse is still responsible for the cost of care. It's just that we may ask them to contribute, but the person would get Medicaid. We can't deny services to them. That if that refusing spouse cannot refuse to, they must provide all the documentation of the resource of income, though. They can say, I'm not going to supply it, but they can't refuse to provide the information.
Okay, and what you're talking about there, Morgan, is the 25% that a community spouse may have that's over the
For
monthly
income or for
minimum.
resources too. Yeah,
Oh, for
but it's at
resources.
25%. Yeah.
Okay, for the MMMA. Now,
And
I know. I know it's the monthly minimum income. That's all I say for the community spouse. Is that going up in 2023 as well? Do you know?
it will be, but it's not that's not changing on that rate, but it will be indexed for,
Okay,
we'll probably, sometimes the state will release that in December, sometimes it's in January, but I don't have a figure for that.
okay. So, but the end game of that is that the community spouse doesn't have to hand over everything over that amount, but only 25% of what they have over that.
That's correct.
Okay. Although they have the right to refuse, but okay. And then I had, speaking of that, another question, because I wasn't sure about this. I thought that you said, if the community spouse, if the spouse who's living, in the community while their spouse is in the facility has an income less than the monthly minimum,
Yes.
but their spouse who is in the facility has whatever, an annuity or a pension or an income that's higher than that, the spouse who's in the facility can contribute to the community spouse's income. Did I hear that? Okay,
we're gonna bring them up to that minimum monthly maintenance needs allowance.
oh, okay, that's really interesting, okay.
Yeah. So
So, okay, got it, so that,
that they're gonna have $3,435 per month.
per
We
month
want-
income, okay.
Yeah,
All right. That's what I hadn't heard that before either, that's really interesting, okay. And,
I saw there was another question and now I don't
Yeah.
see it on trust.
let's see, what documentation do I need if I get Medicaid just to have care at, care at home, I think that means.
No, we talked about that one. It was something about a trust.
So, yes, well, there is a question about that too, but I just want to say, I'm not sure about all the documentation that you're going to get for community Medicaid, but I will send the link as well in the follow-up email, because on the Onondaga County website, it does have a listing of documentation that's required for community-based or home care, so.
Right, you're gonna, but think about your income and your resources though, too. I mean, it's.
Yes,
never-
oh yeah, always, we're always
Yeah.
with Medicaid. Okay, so the question about Medicaid trust, what is the advantage of a Medicaid trust or a special needs trust?
Well, two different, very different, like what's deemed a Medicaid trust is typically called an irrevocable. It's an irrevocable trust where a person will transfer an asset. Frequently, it's a home into an irrevocable trust. It's a home that they've had for a while and they want to protect it. And they transfer it into a trust, and after 5 years, it's a protected asset. You can put other assets into it, but frequently what we'll see a lot of times we'll put a trust into it. You're giving up some control because someone else is likely going to be the trustee over your trust. And if they can build in provisions about selling it and buying replacement property, but it's not your decision. You can keep your star exemption if you put a house in, if it's done properly, but it's about control and it's about protection. And one thing I talk to people, it's like, I don't have a crystal ball to say when you're going to need care. Will you ever need Medicaid care? And is it worth it for you it costs money to set up, and you need to put the assets, you actually have to fund the trust too. So you have to, like, for the way you fund the trust with real property, you do a deed over to the trustee. So you have to put, and if you do it now, in 2 years down the road, you need nursing home coverage, and then you've potentially created a rather large penalty that could create a problem for you receiving medical assistance. So benefits, it's about control, it's about timing, and what are your goals? And what I tell people all the time is, like, you wouldn't do a Medicaid trust, you're not doing it for yourself. Because for yourself, it's not, the house is going to be an exempt resource, there might be a lien against it down the road, but it's not going to impact your ability to get Medicaid. It's about you trying to protect assets for loved ones. So it's only about planning for others. The supplemental needs trust is a little bit different animal, and it's more about disability. Supplemental needs trusts, there's some limitations on aging and making contributions if you're in a nursing home, you're over 65. But supplemental needs trust is a trust that's designed to enhance the quality of your life, but not cause you to lose your governmental benefits. So think of more of a scenario where maybe you had a disabled child and you put assets into a supplemental needs trust that can be there to, again, better the quality of their life. Say, you could send them on a trip, you could buy them a new television or something, but it's not replacing the governmental benefits. And depending on who sets it up, there may or may not be a payback provision at the end of the trust. So a properly set up third-party supplemental needs trust. So me as a parent, if I set up a trust for my supplemental needs trust for a child that's over 21, I no longer have a duty to support that child over 21. But I don't want them in there receiving supplementals or SSI. and I don't want them to lose those benefits, I could put money into a supplemental needs trust for their benefit.
Hmm.
And it could be used over time and they wouldn't lose their Medicaid. That's what's called a third-party supplemental needs trust, where someone that's not responsible created it. So a grandparent could do that for a grandchild. They're not responsible relative. The first-party supplemental needs trusts many times come from like proceeds that may have been received from a lump sum, maybe a personal injury or something like that. It's your own funds being used to create a trust for your benefit. Again, not to lose the governmental benefits, but there can be a payback provision at the end.
Hmm.
So when you pass away, what's left in the trust may have to go to the state at that stage, or to social services. So
Wow.
we could spend just days speaking about trusts and the different types of trusts and what the impact is on Medicaid, but
I know it sounds like it. Nothing is easy, but it does sound like what you're saying is that a Medicaid trust can be beneficial in some circumstances, but not always.
yeah, I mean, yes, it can be very beneficial. And talk to people if it's like this is, home is their primary resource. They worked hard for it and they want to make sure it stays in a family or is protected. Or even if it was a secondary home, maybe it's a family camp or that's been in the family for a long time, and that's not an exempt resource ever. It's a secondary home. It's not your primary residence. It may be worth protecting.
Right.
Those are, planning's not a bad thing. Using the statute and taking advantage of what is available and legal to do is not. So talking to people and having a plan is never a bad thing.
Not a bad thing. And Carol, I will let you know, Carol asked that question, that we will be having a class on November 2nd, I believe, on estate planning.
I did see that, yeah.
And so hopefully, some of those questions will be asked, or you can register for that and send in your information, because that will be more focused on that. Like Morgan said, he could spend another hour on that topic alone. So it's, complicated. And I think that's it. I think that's all the questions. We just hit 6:46, so we're doing perfect on time. And I just want to say to you, Morgan, thank you so much again for taking time in your evening and coming and helping a little bit.
I know it's.
I know. I laughed out loud in the beginning when you said that. Yeah, the title is false because I'm not going to make any sense of Medicaid. So, I know. Okay.
I wish I could to make it easier, but it's complicated.
I know, but I so appreciate it. Thank you, everyone, for being here. I'll send out a follow-up email. It won't be till probably next Monday or Tuesday with some of the information that we talked about, the PowerPoint, the link to this, and hopefully we'll see you all in another class. Thank you.